communications with Mr. Colangelo.
So you don't know if anyone in the department has?
As I said, there's 115,000, and I don't know what they've talked about.
So if I asked for further information and sent you a letter, could I get some of these questions answered? I've asked for correspondence. I sent a letter back in April and haven't received a response. You said in your testimony that you've gone to extraordinary lengths to get Congress information they request.
Yeah, look, I'm in favor of transparency because I believe it will show that these allegations about some kind of control or collusion between the department and the independent Manhattan office are not true.
So then would you...
We'll take back your letter and we'll try to get a response to you.
To kind of follow up with what Mr. Gates said earlier this morning, will you commit to releasing any communications between your department and the local DA offices in New York or Atlanta with respect to these Trump trials?
I'm going to commit to look, I would like transparency on this matter. In the normal course, if you submit your letter, our Office of Legislative Affairs will get a response to you.
Because I think one of the problems here is we hear you criticize some of us for being critical and accusing you all of a two-tier justice system. We use the term weaponization of government, but then when we ask you all for information, you tell us we can't have it, or you've decided that we shouldn't have it. So it's difficult when you criticize us, but we don't get the information we're asking for.
I'm not criticizing you, and in fact, we produced 92,000 pages of documents in response to hundreds of requests.
You've called some of the things we've said conspiracy theories. I won't read back your testimony to you, but I've printed it since your office posted it online this morning. And I would just ask you to work with us because it's difficult for us to tamper down some of these claims that you say we're making when we don't get the information we request from you all. I'll yield.
That's fair. I'd be happy to work with you to tamper this down.
Thank you.
Absolutely.
Hey, we'll tamper away if we can get the information we're asking. I'll yield back to you.
I assume that's a verb. I'm with it.
That's right. Thank you. Mr. Jordan, I'll yield to you.
I appreciate the gentleman yielding. I'm going to go back to where I was, Mr. Attorney General, a few minutes ago. I want to read from this Politico's news story from 1 week ago today. I just want to read two sentences. It's the first two sentences in the article. The Justice Department has agreed to settle a long-running litigation stemming from a decision in 2017 to release to the media text messages between two former FBI employees involved in the probe of Donald Trump's 2016 presidential campaign. Next sentence. In a notice filed with two federal judges in Washington on Tuesday, the Justice Department said it had reached settlements of legal claims that fired FBI agent Peter Strzok and former FBI attorney Lisa Page brought in 2019, alleging that the disclosure violated their privacy. So again, I just want to be clear that the department is getting ready to pay Peter Strzok and Lisa Page some money. Is that accurate?
I wasn't aware that we'd announced it. All I can say is we reached settlements based on our litigators' assessment of whether we can win the case and how much it will cost if we lose the case. That's the way we decide on reaching settlements.
Just to be clear, the guy who texted Peter Strzok, who was involved in the spying on President Trump's campaign, who was then involved, worked on the Mueller investigative team, and sent this text message to Lisa Page, just went to a Southern Virginia Walmart. I could smell, in all capitals, I could smell the Trump support. That guy's going to get tax dollars from the American people?
That case is he brought a case under the Privacy Act. The question is, did the Justice Department violate the Privacy Act?
Lisa Page said this in a text message to Peter Strzok. Trump's not ever going to become president, right? With a question mark. Peter Strzok's response, no, he's not. We'll stop it. And these two individuals are going to get a windfall of money from the American taxpayers because you decided that's the right thing to do?
The Privacy Act doesn't distinguish between people we like and people we don't like, information we like and information we don't like. If somebody in the government discloses personal information protected by the Privacy Act, that's the way the law is.
Jeepers, you can go after a president and you get rewarded for doing so, according to the Justice Department.
It's not a question of reward, it's a question of the government paying for violating the law.
They're going to get a lot of money, and I know that this is what they said. We know what they were up to. The chair now recognizes the gentlelady from Vermont.
Thank you, Mr. Chair. Thank you, Attorney General Garland, for being here today. I know it's been a very long day, and I just want to start by saying, may the record show that although I'm a Vermonter, I do not partake in cannabis products, but after today's hearing, I could understand why someone might want to actually pop a gummy. It is maddening to witness so many of my colleagues seeming to care more about propping up and protecting a convicted felon than protecting the rule of law. And last week was a district week, so I was back in my home district, and I got asked the following questions a lot, and this was from people from across the political spectrum, Democrats, Republicans, Independents. They asked me the same questions. Why do they protect him? And the him in question is, of course, the former president. And they asked me, are they true believers? Are they apologists? Are they enablers? Are they just scared about what's going to happen to them if they don't defend the former president? I don't know. But I do know history is going to reveal the answer. The truth will out. The truth will out. Now, I'd like to leave the land of make-believe and talk about something that really matters to my people back home, which is the fact that we have a crushing housing crisis in Vermont right now. And the last time you sat before this committee, less than a year ago, I applauded your remarks on DOJ's increased enforcement against corporate crime, and in particular, DOJ's actions to take on corporate consolidation, price-fixing, collusion. And since coming to Congress, I've tried to focus a great deal on finding solutions to the nation's housing crisis, and in particular, what's happening in Vermont. In my home state, we saw a 12% jump in home prices over the last year. That's twice the national average and the highest yearly increase across all states. So part of the problem is lack of supply, but that's not entirely what's causing skyrocketing home prices. It's not just a lack of supply. There's corporate greed at work here too. So so-called property management software companies like RealPage and Yardi are making the housing crisis worse by facilitating unwarranted rent hikes by landlords. And I will say, you don't have to take my word for it. You can go right on the homepage of RealPage, which boasts that they increase rents for client landlords between 5 and 12% in every market in which they are coordinating prices. So in fact, one of the software developers told investigative journalists that leasing agents, quote, had too much empathy compared to computer-generated pricing. So this is how price-fixing cartels operate. So I know that DOJ is concerned about price fixing. They're concerned about this issue, and I know you can't speak on the particulars, but can you please talk in the abstract about the importance of price competition in markets and the role of antitrust law in maintaining competitions?
Yes. The theory is that if suppliers do not collude with each other, if they offer the price that each wants, and those customers then meet them in an equal marketplace that will reach an efficient price that will be in the best interest of resource allocation, and particularly with respect to consumer prices.
And do you...
When they collude, when the suppliers collude, they create a monopoly price, which is not good either for the economy in general, but is certainly above the market price. And the kinds of things you're talking about in general, price collusion, which is exacerbated by data collection and logarithms that set suggested prices, that can lead to a price above the competitive price, which costs consumers more.
I thank you so much. I see that I'm almost out of time. Just want to end by saying what many of my colleagues have said before me. Thank you for coming today. Thank you for being willing to answer our questions. And I very much appreciate the expertise that you bring to your job. Thank you so much.
Gentlelady yields back. Gentlelady from Wyoming is recognized.
Mr. Attorney General, are you above reproach?
I'm not above criticism. I'm not sure what you mean by reproach, but of course, you're totally free to criticize me, and I expect
Yeah,
you
as
will.
American citizens, we can criticize you. We can criticize all of our government employees, can't we?
Absolutely.
Because you seem to whine quite a bit today about being attacked or people challenging the decisions that you've made. I actually think that Daniel Greenfield, a contributor to Front Page Magazine, may have said it best when he said that a justice system can survive those who challenge the prosecutors, but it can't survive those who prosecute the challengers, which is kind of the situation we're in with the Biden administration and you at the helm of the Attorney General's office. Attorney General Garland, in March, Chairman Jordan and I sent you an oversight letter requesting documents and information following the release of an undercover video indicating that the DOJ was working with the IRS to use artificial intelligence to surveil bank accounts of Americans in a clearly unconstitutional manner. The undercover video featured an IRS official privately admitting that the IRS had been using AI to spy on Americans' bank accounts en masse in real time. The IRS official further stated that the Department of Justice and Inspector General controlled this AI-powered warrantless surveillance system, not the IRS. Attorney General, would you agree with me that if the federal government were operating this form of financial surveillance program, there would be serious Fourth Amendment as well as other statutory and civil rights implications, considering that there is no individual probable cause and no search warrants are being obtained?
I would be stunned if the Justice Department has the kind of AI
Would you-
capabilities that you're talking about.
Would you agree with me that would you agree with me?
To learn about this.
Would you agree with me that if they were engaging in that kind of surveillance, it would have serious Fourth Amendment implications?
I can't understand the kind of surveillance that you're talking about. Fourth Amendment prevents unreasonable searches and seizures without a warrant. If that's what we're doing, then of course that would violate the Fourth Amendment.
Okay, so I would request that you go back and read the letter that Jim Jordan and I sent to you. That might clear up your confusion just a bit.
I'll be happy to do
Now, while the committee has been following up with the department about this matter for months now, the department only replied with a formal response to the committee late last week. In the department's response letter, a DOJ spokesman, the Assistant Attorney General, Carlos Iriarte, stated that the department is, quote, not aware of the department using any AI program that reflects the description in our March 20th letter, end quote. But saying that the chief AI officer is, quote, not aware of the department coordinating with the IRS to use AI to unconstitutionally spy on Americans' financial records is very different from saying unequivocally that the department is not doing so. Why won't the department just give us a clear answer as to whether it is actually using AI to spy on American citizens' financial records?
I'll be happy to take your letter back, and apparently you already have received a letter. I'll take it back, and we'll see whether we can get you a clearer letter for you.
I would appreciate that. I want to turn to another serious issue, the infiltration of our tribal communities by the Mexican cartels because of Joe Biden and Mayorkas's open border. As chair of the Subcommittee on Indian and Insular Affairs, I have heard from tribes across the nation about this issue. In your written testimony, you actually mention how the department is working with tribal partners to disrupt cartel supply chains and that the department is zeroing in on the Sinaloa and Jalisco cartels. However, in April, the president of the Fort Belknap Indian community testified to the department's failures, stating, quote, we don't have help from the FBI, the Border Patrol, the DEA, that has jurisdiction on federal lands, which are reservations. Attorney General Garland, his testimony comes from a tribe where the Sinaloa cartel operates with near impunity in its region. Drugs have devastated the community, reservations have become part of the cartel supply chain, and the Mexican cartels are intimidating Americans testifying before Congress. Yet the FBI and DOJ are largely absent. The tribe's experience runs in direct contrast to your testimony. Have you been in contact with any of our tribes about the impact that mass illegal immigration, human trafficking, and drug smuggling are having on their members?
Not only have I been in contact with the tribes, I've been on the reservation in Montana and Alaska. The answer to your question is Congress is not giving us money for FBI agents to go into the reservations.
Oh, so this is Congress's fault that you won't do your job?
It's Congress's
This
fault.
is Congress's fault that you won't protect
I will do
our
my-
reservation, that you won't protect our reservations from the consequences of the Biden and Mayorkas open border policies. That's Congress's fault, not theirs.
If you give us money for more FBI
Oh, you
agents
need more
for the
money for FBI
reservations,
agents.
they
How
will
about
go
if
to the
they just
reservations.
enforce the border? How about if you ask them to enforce the border?
The time of the gentlelady has expired. The gentlelady yields back. Does Mr. Ivey have
We're out on this side, but I would offer
unanimous consent?
unanimous consent for 2 letters that may address Ms. Hageman's line of questioning. One is dated April 22nd, 2024, from the Department of Treasury, and it's addressed to you, Mr. Chairman. It's from Corey Tellez, who is the acting secretary, and the other is, she may have referenced, I'm not sure, from the Department of Justice to you, Mr. Chairman. It's from Mr. Uriarte. It's dated May 31st, 2024.
Without objection.
And I would ask for unanimous consent for an article, Cartels Infiltrating Native Reservations with Fentanyl, according to a tribal leader.
Thank you. Without objection. Gentlelady yields back. Gentlelady for Florida is recognized.
Good afternoon, Mr. Attorney General. This committee is well aware of your long tenure as an appellate judge on the D.C. Circuit and your time as an AUSA before that. And I am sure that you, like me, care deeply about the public confidence in our court system and specifically our judiciary. And you said something a few moments ago that I think is a very important principle. You said that judges put aside their personal views and their political views when they preside. And I agree that that is the expectation. Not that judges don't have personal or political views, but that judges set those beliefs aside when they consider and rule upon cases, and that they do so in a way that is impartial and consistent with the law. And so I'd like to discuss the recent increase in aspersions being cast at some of our Supreme Court justices, some of which we've heard repeated during this hearing. Public calls for recusal of justices based on conjecture and conspiracy about their political beliefs, and in fact, not even the supposed political beliefs of the justices themselves, but even more attenuated to the supposed political and personal beliefs of their wives. In your view, Mr. Attorney General, is it appropriate to attack the impartiality and integrity of the Supreme Court justices in this way?
So I'm going to have to say again what I said before, which is we have cases before the Supreme Court, so I'm not going to be able to comment on this. You haven't heard any aspersions cast by me, and you won't hear any, but all of our filings will be done in court, and I'll only speak about these matters in court.
So then let's discuss this not as it relates to the specific justices who have had their integrity attacked today, but more generally in the case of judges who are presiding. Now, in general, in your experience on the bench, did judges in the D.C. Circuit recuse themselves if they believed they had a conflict of interest?
Yes.
And in your experience, did they typically adhere to a very high standard of personal integrity?
Yes.
And do you have any reason to believe or any personal belief that the justices of the Supreme Court currently have any issues that would necessitate their recusal?
So you've now skipped over to the question, which I said I wouldn't be able to answer. I can't comment about the Supreme Court. We have cases in the Supreme Court right now, and all the time.
So let's talk about the matter of judicial security. So not long ago, we had Director Wray of the FBI appear before this committee, and I questioned him about the lack of FBI resources and focus being allocated to threats against the safety of judges and specifically Supreme Court justices in light of some of the alarming news in recent times. And one of the things that he pointed out, in fairness, was that the U.S. Marshals take a large role when it comes to the security of judges. But in your role, you have the unique opportunity to actually oversee both branches there. So I'd like to know more about what the department is doing related to threats against judges.
Okay, fair enough. So this is one I can talk about. With respect to the justices themselves, for the first time in history, an attorney general, namely myself, ordered that every justice get 24/7 protection for himself or herself and their families at their residence and on their travel. So I've assigned over 70 U.S. Marshals who are doing this daily, but because of rotations, it's involved almost 1,700 marshals across the country to provide immediate protection. Now, the FBI, both the marshals and the FBI investigate threats against the justice. This is in our highest priority band protection against the judges, protection against threats against justices and judges. And I'll be happy to provide you with the press releases of our charges. There have been threats against several of the justices, and we have brought cases against those who have threatened them. We have a lot of judges in the country, and we don't have enough marshals. So I'm sorry to say the same thing I said before, which is we need more money for the marshals for protection, because not only do they protect the justices, they have to protect the judges in courthouses in 94 districts in the United States.
Thank you, Mr. Chairman. I yield the balance of my time.
Gentlelady yields back. The gentleman from South Carolina is recognized.
Mr. Chairman, I yield 1 minute to you, sir.
Oh, thought that was coming at the end. Thank you. I think the gentleman for Ely. Have you looked at, Mr. Attorney General, have you looked into who leaked the Dobbs draft opinion at the Supreme Court? Has the Justice Department looked into who was responsible for leaking the Dobbs draft opinion at the Supreme Court?
Well, I believe the Supreme Court did its own internal investigation. They didn't ask us to look into that.
Yeah, but we don't know who did. I'm just asking, is that something that the Justice Department will look into?
I think if the justices of the Supreme Court refer the matter for investigation by the Justice Department.
Was anyone in the Justice Department involved in the leak of the Dobbs draft opinion?
You asked whether the Justice Department was involved?
Is anyone at the Justice Department involved in that leak?
I can't imagine how that could happen. That's an internal document within the Supreme Court, the Justice Department.
I'm just asking.
I would be stunned.
I yield back to the gentleman.
Thank you, Mr. Chairman. Mr. Gates talked about Mr. Colangelo earlier. Mr. Colangelo was acting Associate Attorney General for the Justice Department under President Biden prior to your arrival. Is that my understanding?
That's right.
And is that considered to be the third highest ranking official within the DOJ?
Yes.
Okay. What did he do prior to his service with the Department of Justice?
I didn't know Mr. Colangelo before. My understanding was he had once been in the Civil Rights Division. I don't know his resume.
Would it surprise you to know that he was the Deputy Director for the Obama-Biden administration's National Economic Council?
It wouldn't surprise me or not surprise me. I don't.
Were you aware also that he worked for the New York Attorney General, Letitia James, for a period of time?
I've read that in the paper.
Okay. Would it surprise you to know that he was paid thousands of dollars by the DNC for political consulting in 2018?
So that I have no idea about.
So I think the issue that we're having is that it looks like that this particular gentleman, his whole mission seems to be prosecuting a president. He started off with Letitia James. He has a stint with the Department of Justice. And then Mr. Gates kind of talked about this earlier. Normally, if you're going for something, you start out at a DA level and then you might move to the Department of Justice. Like it's an elevation. He has gone backwards. Why is that, you think?
Let me just set forth the whole thing here if I can, okay? I know Mr. Colangelo because of his service in the department. He's a highly ethical person and an excellent lawyer. The Associate's Office supervises the Civil Division, the Civil Rights Division, the Antitrust Division. That office does not supervise any of the criminal components that supervise the investigation, the criminal investigations of Mr. Trump.
Don't you think, though, Mr. Attorney General, that his career choices, the path that he has chosen, at a very least, poses the perception of an ethical issue for the Department of Justice?
No, I don't see how it poses any issue for the Department of Justice. He's not an employee of the Justice Department. The Justice Department did not send him to New York. Those decisions in New York are made by the DA of New York.
Well, fair to say, but we have a, Manhattan DA headline, Manhattan DA hires ex-senior DOJ official as office investigates Trump. Another one from the New York Times, Manhattan DA hires ex-justice official to help lead Trump inquiry. Now, you might not have had anything to do with that, but the perception is, and the American people perceive, that the Department of Justice is intimately engaged with this. And I think in my last minute here, here's the issue that I think that people say, that in polling shows this consistently, that the American people believe that the prosecution of President Trump is more about politics than it is about any violation of the law. In the DOJ's own words, its mission consists of independence and impartiality, honesty and integrity. At your Senate confirmation hearing in 2021, you said the department will be under my protection for the purpose of preventing any kind of partisan or other improper motive in making any kind of investigation or prosecution. But since that time, the DOJ has obstructed this committee's impeachment inquiry. It's allowed the statute of limitations to run, to expire on Hunter Biden's 2014 tax records and the crimes therein, slow-walk the prosecution of Hunter Biden as testified to by whistleblowers. You wouldn't allow investigators to follow department protocols. You've limited witness testimony here in this committee as we try to provide oversight. You've limited the scope in which they can actually say and the number of witnesses, and instructed 2 of the employees to disregard this committee's own subpoena. You refused to comply with the subpoena regarding the audio tapes, hence the contempt, the regrettable and unfortunate contempt that we have to bring. You appointed Jack Smith to prosecute Trump despite his very interesting career of losing cases and targeting political opponents. You sanctioned a raid on Mar-a-Lago, and the concern that we have is that you're either asleep at the wheel or you're intentionally allowing the department and the agents therein to engage in political prosecution of their opponents. Thank you, and I yield back.
Gentleman yields back. Close our day. Soon to be governor of this great state of North Dakota.
Thank you, Mr. Chairman. I feel like I sometimes have a unique space, particularly on this side of the aisle, in that I've been trying to be a good-natured pain in the Department of Justice's rear end my entire adult life. And since I've been here, I've worked on things about law enforcement's use of third-party data brokers, geofence warrants, civil asset forfeiture reform, acquitted conduct, and exculpatory evidence, SAPR supervision, BOP oversight. I've fought for extra money for public defenders, and when Mr. Ivey's talking about those guys he was talking to in church, I was the guy at council table with him. So,
Not here, maybe.
oh, I'm sorry. I was just saying, like, I spent a significant portion of the early part of my career as a public defender and dealing with that. So I take this stuff seriously, and earlier today, you said it is our view that audio recordings are essential and people are less likely to participate if they know those are going to be turned over. It will have a chilling effect on the cooperation of future witnesses. It's happening right now, and career DOJ officials have told you that, correct?
Yes.
But the second part of that is when you want to. And the reason I know this is, and I hate the fact that oftentimes, in order to get answers to some of these questions, we have to go to these highly political and profile cases. But we introduced the FAIR Act, and we had all but one member of this committee vote for it. And that is requiring Department of Justice to record DOJ, ATF, FBI, DEA, and the Marshal Service to record custodial interrogations and non-custodial interrogations. And we know that the DOJ interviewed Paul Manafort 4 times and never interviewed him. By the way, it's not only the DOJ. When we sat in a deposition, Hunter Biden's lawyers requested that it wasn't audio recorded or video recorded. Now, I have my suspicion why, and I think it's because things read differently than they sound. But in 2004, the FBI issued a report in favor of recording interviews because of the following benefits: reduce court time for officers to appear in suppression hearings, improve court efficiency with fewer pretrial motions to suppress statements and confessions, officer efficiency due to no longer needing to review and piece together notes from interviews, reduction in lawsuits stemming from frivolous claims of misconduct. And in 2014, and this is all before you were the Attorney General, but you're in the big chair and we're last, so we get that. President Obama created a presumption that interviews of federally detained persons should be electronically recorded. The problem was, and the reason we introduced this bill, is the DOJ's determination of in custody was after arraignment before trial in a federal building. So my question to you, which we can start with, is why, if they're so essential for you to record them that it will chill future cooperation, the recording in and of itself has no benefit. I mean, it has benefit to your guys, but when you don't have to turn it over, you are arguing that recordings are essential. But you and I both know in a criminal case that if you have the recording, I'm going to eventually get it as the defense attorney. So I'm trying to figure out what your guys' policy is on recording of interviews and recording of witnesses. Because if it was what it really says it was, we wouldn't have had to introduce the FAIR Act.
Well, like you say, there are very few things that are before my time, but that one does seem to have been before my time. I don't know the answer to the policy about recording. Personally, I think recording interviews is a very good thing to do for all the reasons that you say. But of course, as a former defense attorney, you know that the defendant has to agree to the recording of the interview.
We've been a part of it in this committee too, and I get the rules of evidence in a criminal case are different than an adversarial between the Department of Justice and Congress. But our frustration, and my personal frustration, is whenever you're in an adversarial system, the other team doesn't get to determine what is the best evidence. And I'm not talking about the best evidence rule. We've had that conversation forever. But it's fine, but when we know it exists and we ask for it, and then you say, I mean, and some of this is timing too, and with all due respect to everybody, we get the transcript the day before the first hearing. We get executive privilege put into place literally the morning of the contempt hearing, and we're looking at it and saying, listen, we know it exists, we want it, and you're saying that there's some political reason for us not getting it, but I will argue, and I will argue at the rooftops, that the real political reason is to not give it to us. Because anybody in any determination of fact anywhere in the country knows that if you have audio or video, that is better than a transcript. If you have a transcript, that's better than notes. And that's what the committee is trying to get here, and that's what the committee is being stonewalled from when we know it exists, and that's why we're so frustrated. And I personally believe that there's a very, very specific reason that executive privilege was instituted the morning of the hearing, because the difference between this and a criminal case is we actually have a potential time clock, and that's the November election. And with that, I yield back.
Could I respond? You have time for response?
Yep.
Sorry. I know, but I like talking to you, and this seems like a good conversation, if you don't mind. So two things. One, with respect to the timing, since the Clinton administration 30 years or so ago, it's been standard that assertions of executive privilege occur right before the vote in order to provide the constitutional accommodation process as much time to run as possible. So that's the answer to that thing. The answer to the other is the Supreme Court has said that in order to protect the separation of powers under the Constitution, the Congress has to have a legitimate legislative purpose for the things that it's requesting. And what I'm still not seeing, I understand why you'd rather see the audio, hear the audio, than read the transcript, but I still do not understand a legislative purpose. I can't see how listening to the audio will make any difference with respect to any legislation you have in mind. If you want to have a statute that requires special counsels to turn over audio all the time to the Congress, you can pass that without listening to this audio. And I don't see, there's no element of the impeachment resolution that will change with respect to information on the audio. The words are the same on the transcript as the audio. That's my explanation.
I am actually excited to see potentially how that gets turned out in the more respectful way. By the way, it would really, actually in this current political environment, I'm not sure if it would help or it would hurt, but the FAIR Act's a really good piece of legislation and your support would be helpful. And with that,
I'll look into whether we're following the FAIR Act or not. That's a very good point.
your career DOJ officials are following it, I promise you.
Gentleman yields back. That concludes today's hearing. I want to thank the Attorney General for being here and for the several hours that he testified. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. Without objection, the hearing is adjourned.